Going on? I wanted to start basically do a video in regards to some sauce that some of y'all don't know. Some people know this. Most people may not know it. But I'm gonna get to the video, get to the feature presentation. And my cologne today is Initio. I forgot. So I just grabbed one. I was like, oh, that smells good. All right. So we need to understand how you get into a situation. And many people who've done consultations with me, they understand that I always tell you the way you get in a situation is the way you get out. Okay. So if you don't understand how you got into the situation, then you don't want to go around making allegations and assuming things. And this is where people get themselves in trouble. They'll go around, they'll start assuming, oh, the Federal Reserve window is how all loans is made. Okay, can you prove that? No, you can't. Okay, so stop trying to argue with people and stop trying to prove stuff that you can't prove. This is what makes you look crazy when you argue with certain people. So when they hear stuff in this movement, they'll be like, oh, that's sovereign citizen stuff. But you know, it's hard to explain certain things. So I'm gonna get to it. So first you always gotta understand, how do I get into debt? Okay. It's not just the underlying agreement. Okay, the underlying agreement shows the terms of the debt or terms of the managing of the account. Okay, when you get a loan, a credit card, etc., that document is basically showing the grounds for the agreement. Okay, but how you get into debt and like third party debts, like a debt collector sending stuff to you, initial so called creditors sending stuff to you. Remember, you're not a creditor until you have liability on your books. So you have to have liability on your books to be a creditor. If they don't have liability on their books, they're not a creditor. Okay. So first, one of the most important things that you need to understand is the mailbox rule. Okay. When somebody is sending you a letter in the mail, they're not sending you a love letter. It's not with the intent to help you or to assist you. So that means that it's at your detriment. Okay. So the mailbox rule, also called the posting rule, refers to the default rule in contracts law for determining when an offer was accepted. So when someone is sending you a so-called bill, they're sending you an offer. Okay. So the reason why they're sending you this offer is they're hoping that by your action that you do something that causes you to go into default or gives them the opportunity to default you. So a default judgment in general is not bad. Some lawyers will be like, "Oh, it's the end of the world." No, it's not. If you can invalidate the whole process, then it's not bad. Okay. So under the mailbox rule, an offer is considered accepted the moment the offeree mails their letter, rather than when the offerer receives the letter in the mail. So when they're sending out a mail, the presumption or the offer in the mail, the general presumption or the general consensus is that at that moment, that offer is assumed to be accepted. So do you guys get it? When someone sends you a bill, it is assumed to be accepted. So let's go back to UCC 1-307, which is the Uniform Commercial Code. And this is prima facie evidence by third party documents. Okay. So a document in due form purporting to be a bill of lading. Okay. Look, see what a bill of lading is while you're clicking on the Uniform Commercial Code. Look and see what the definitions are. Definitions will give you a greater understanding of context because different statutes have different definitions. So people will use a definition in one statute to define something else and be wronged in a mug about it. Okay, that's why you have to be careful when using statutes. That's why I look for the general meaning. What is the common parlance of the word? So, bill of lading means a document evidencing the receipt of goods for shipment by a person engaged in the business of transporting or forwarding goods. policy or certificate of insurance, official wares or inspectors, a certificate, consular invoice, or any other document authorized or required by the contract to be issued by a third party is prima facie evidence of its own authenticity and genuineness, and the facts stated in the document by the third party, unless challenged. So we come right back to the mailbox rule, and voila. Now do you understand UCC 1-307 a lot better? When someone sends you an offer in the mail, it is generally deemed as accepted unless you send either new terms, you do an attachment, you do an endorsement, you do a challenge, you do an adoption of the record, you do an or you can just dispute, default on it or dispute the charge, etc. So under the mailbox rule, an offer is considered accepted the moment the offer. Okay, I already read that. So it is irrevocable once sent. The mailbox rule originated in British case of Adams versus Linsdale in 1818. In that case, the court determined that the buyer accepted the seller's offer to buy wool when they responded to the seller's letter, not when the seller received their reply. So they're saying the presumption that you accepted it was the moment that it was sent. So unless you take that record and challenge it and say, I did not accept this, blah, 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 or I accepted it on this date, then they're going to go under the mailbox rule. So remember, under the mailbox rule, when a person can prove that they mailed something to you and they could prove that they mailed it to an address that you lived at, then they can enforce it against you. It doesn't matter if they have your current address. They can send it to an old address and still get a default judgment, but you'll have to go into court, clear that up, saying I never received it. As a default rule, it does not apply in all cases. Parties can contract around the mailbox rule to change at what time an offer will be considered accepted. See, just like I said, you can do a letter or an attachment or an affidavit stating that you did not accept the offer on that date, and this is the date that you're now challenging and accepting the offer. You can do this with any offer. So if you're in default in an offer, you can update and challenge the acceptance of the offer. As with most contract law, the mailbox rule varies from state to state. In minority states such as California, the mailbox rule applies to option contracts. In most states, however, it applies only to bilateral contracts. So that means that you can create a bilateral contract just like they can create a bilateral contract. This is the part that I'll be trying to get people to understand. Is that people need to understand just the way a bank can create a contract with you, you can create a contract right back with that bank. And that's what people are scared because they're like, oh, they might close my account. They might do this. They might do that. Well, you have to know what to do in that situation. So don't do anything if you have fear, because fear is like cancer. I mean, once it's in you, you can't stop it from spreading. So you have to get that stuff up out of you. Okay. Restatement, second of contracts, subsection 63, 1983, echoes in the opinion of many states distinguish between an option contract and a bilateral contract. The reinstatement reads, unless the offer provides otherwise, an acceptance made in a manner by an medium invited by the offerer is operative and completes the manifestation of mutual assent as soon as put out of the offeree's possession. So they're basically saying, so as soon as you put out something, as long as the document shows mutual assent, it's enforceable, okay? Without regard to whether it ever reaches the offerer. But that's what I told you. They don't have to have your address. All they have to do is have your last known address, and they could still default you and take your house or take your stuff if they have your last known address. You have to change your address in their system, okay? But B, An acceptance under an option contract is not operative until received by the offerer. Okay, they're talking about an option contract. So, in other words, under jurisdictions which have adopted the reinstatement rule, the mailbox rule doctrine applies to bilateral contracts, but not option contracts. So, an option contract is an agreement that conveys the right to purchase property or engage in a transaction in the future upon agreed terms. So, as defined in 7 USC, the term option means an agreement, contract, or transaction that is out of character of or is commonly known to trade as option, privilege, indemnity, bid, offer, put, call, advance guarantee, decline guarantee. Some common use of the term option in a legal sense include in context of contracts, cases such as this one from Texas explain that an option, privilege, or right that the owner of property gives another to buy certain property at a fixed price with a certain time. Additionally, in this case from Colorado explains that a contract of sale creates mutual obligations on part of seller to sell and on part of purchaser to buy, while option gives the right to purchase within a limited time without imposing obligations to purchase. All right, so we have to deal with this and understand what context this is stated in, and then when we understand the context it's stated in, we need to understand that all offers are considered as presentments. So one of the best publications, and I got this from High Frequency Radio, is Dealing with Presentments. It is a publication that is a must. If you are a beginner, if you are learning this information, you need to understand that everything that is given to you is an offer. That's why you don't need to panic. So just like in a court case, if they're saying we could give you 6 years in jail, that's an offer. Just like in a court case, if they say we can give you 7 years to go to prison, that's an offer. You don't have to accept it. Just like they tell you you could go on parole, you don't have to accept that. But what people do is they're afraid to go to trial, even though they may win if they actually knew the rules of evidence, they knew the rules of that, then they would win. You can't expect an attorney to barter on your behalf when you're ignorant. Okay. The attorney's going to do what's in the best interest of them, what's in the best interest of the court, because you are deemed as a minor and you are ignorant. So if you are going to hire an attorney, make sure you know what you're doing, because you can hire an attorney if you know what you're doing and give them orders and they'll have to comply with it. So presentment means a demand made by or on behalf of a person entitled to enforce an instrument. Okay. To pay the instrument made to the drawee or party obligated to pay the instrument, or in the case of a note or an accepted draft payable at the bank, or to accept a draft made to the drawee. Okay, so when you guys receive bills, you don't accept them, you don't transfer them, you don't endorse them, and that's what makes you liable. So when you go back, now you see why you're liable. You're not liable because you have a social security number. You're not liable because of the 14th Amendment. You're not liable because of the United States. You're not liable because you're straw man. That's BS. I've already debunked the straw man. Why are people still debating and stuff? You see what I'm saying? People are debating stuff I've already debunked. I've already debunked HCR 192. It's been debunked that. You see what I'm saying? I'm already debunked the straw man. I've been debunked that stuff. So all this stuff people tell you, oh, because it's this and this and your uppercase letters, wasting time. You get a presentment in the mail, they're sending it to whoever is at that address, who has the authority to accept or to transfer or to challenge. That's what they're sending it to. So all of this uppercase, lowercase, side case, all this other stuff, people keep looking up this stuff and they don't even understand what capitis diminutia is. Okay. All right, I'm gonna teach reading comprehension classes. That's what we need to do. Keep it 100. It's not even joking at people. I'm telling people we need to increase people's reading comprehension. So presentment may be made at the place of payment of the instrument and must be made at the place of payment if the instrument is payable at a bank in the United States. So most of you guys don't even read your actual agreements to show how you can do remittance coupons, how to do endorsements, how to make presentments to the bank. Because all you have to do is follow this. You can make an instrument that is payable at any United States bank. That's why I don't charge people for remittance courses. In my opinion, I think that's kind of, I'm not, I have ethical issues with that, but I'm not getting into that. So, may be made by any commercially reasonable means, including an oral, written, or electronic communication is effective when the demand for payment or acceptance is received by a person to whom presentment is made, and is effective if made to any one of two or more makers, acceptors, drawees, or other payers upon demand of the other person to whom presentment is made. The person making presentment must exhibit the instrument. So for people who do consultations with me, this is why I tell you you have to show the instrument. So when you're sending your letters, attach the instruments to the letter. Okay, give reasonable identification. See, that's why I say you can do an affidavit. That's one of the biggest functions of an affidavit. Okay, an affidavit is to have sworn statements or testimony or in regards to something. So under a 12B motion, like where they, in Tinsley versus Pagliaro, the reason why an attorney can actually swear to a debt is because if you allow the attorney to do their administrative process, they're going to come through in an affidavit and they're going to swear to their administrative process and not the actual elements of the case. So now you're not arguing facts. So then you have to challenge the facts on the record. And I just gave y'all some court sauce. Okay, if the presentment is made on behalf of another person, reasonable evidence of the authority to do so. So you have to, if somebody, that's why when debt collectors see you letters saying we're working on behalf of the bank, you can ask for proof that they're working on behalf of the bank. What agreement do you have between you, me, and that bank that says that I have to perform? And if they show the agreement and it has an assignment, be like, oh, this is not enforceable by your agency because this is a security and I have a proprietary security interest in this. So you don't have a right to collect. And going on further or trying to collect further will now make you a liable party. So this is where people have to understand. So sign a receipt on the instrument for any payment made or surrender the instrument if full payment is made. See, this is why I be telling y'all, man, this stuff is so simple, dog. It's so simple. And people want to make it complex. A lot of people are out here deceiving y'all, man. They got y'all going in different avenues and all different places. Now, I know some people, they have good intentions behind it. This stuff is very simple. You guys need to learn how to read the documents that you are receiving and look up what you should do with those documents. And with that being said, I'm not going to read anymore. I hope everybody has a great day, and I hope you got a great benefit off this video as usual. This site is going to be pumping out a lot of good information to starting businesses, information in regards to getting loans and getting your finances right. So we expanding, baby. We expanding. So I'm thankful for everybody who was along for the ride from the start. It was a rocky start, but it was a start nonetheless. And now we taking off, man. So I'm just thankful for all of you guys that watch these videos because I really want y'all to learn. You know what I'm saying? So with that being said, I thank everybody again, and I'm out.